May the court rise?
I understand the Lordship came back at 2, only to find the court empty, at least without us.
That is so, Mr.
I just wanted
Mkhwebane.
to apologize on behalf of my team.
Yes.
Our understanding was that the Lordship had said we will take the 1 hour adjournment at 1:15.
Yeah.
That's why we intended to be here at 2:15.
Yes, I appreciate it was a misunderstanding. Mr. Mpofu?
Mr. Mutau protests at my description of the court being empty.
Yes, it should be mentioned that Mr. Mtau was here at 2.
Well, my lady, sorry, my lord, I will deal with that when I deal with the interpretations of my conditions of sense.
Well, all I can say is that he's not going to get a gratuity for that. My lord,
Mr. Mpofu.
yes. I just wanted to round up one issue by referring your lordship to, under the main section, to paragraph 50 of the Apollo case that I referred to.
15.
50, my lord.
50.
Yes.
Yes.
And in that paragraph, Justice Sutherland relies on a case called Imatu versus Umhlatuze, and says, quote, and this covers, by the way, the next point which they rely on the other side. So you'll remember, my lord, that they say it's not a legal entitlement. Then they say it's a discretion. And we say it doesn't matter. If it's a legal requirement, as I've explained, then X what happens. But we're saying even if it's a discretion, then that discretion was exercised capriciously because we were not given a hearing and so on, which I'll deal with in the next section. But here I just want to show that in terms of the law, again, that distinction is not relevant. And the part that is found, that is quoted at 50 says, it says the court concluded that, quote, the more plausible, you'll find that at 93, Mala, of our bundle. It says the more plausible interpretation is that the term benefits was intended to refer to advantages conferred on employees which did not originate from contractual or statutory entitlements, but which had been granted at the employer's discretion. In other words, even if the discretion non-discretion divide could be held in their favor, it would not detract from the fact that this is a benefit. And then his lordship said, it seems to me that the court in Imatu was concerned that if benefits include a statutory or contractual right or entitlement, the right to strike might be curtailed. As pointed out above, the employees will have an election to strike or to go to strike. and in respect of many rights disputes and so on. That's irrelevant. Here's the point. In my view, the better approach would be to interpret the term benefit to include a right or entitlement to which the employee is entitled, bracket, ex contractu or ex lege, including rights judicially created, as well as an advantage or privilege which has been offered or granted to an employee in terms of a policy or practice subject to the employer's discretion. In my judgment, benefit in section 186.2 means existing advantages or privileges to which employer is entitled as a right or granted in terms of a policy or practice subject to the employer's discretion. So the point that was made there is that that distinction, to the extent that it's raised, is not relevant. The benefit would still be a benefit. Now, my Lord, if I may then move to the maybe let me round off the point as follows. If your Lordship is, well, your Lordship doesn't have to be with us. If the Constitution is with us, if the Constitution says that benefits such as the ones that we've described here fall under the umbrellaship of remuneration, if the definition of remuneration under the BCEA also encapsulates benefit, as these cases seem to show, and if the remuneration, which is referred to in Section 2.2 of the Public Protector Act, also gives rise to the, among other things, the gratuity, then clearly the two principal questions would have been answered in favor of the applicant. A, being that vacation is not confined to voluntary vacation, and B, that remuneration includes gratuity. And if that is true, then obviously Section 32 of the BCAA kicks in, which means that it was payable within 7 days. Or that the non-payment thereof is a breach not only of the service conditions of the BCAA, but also of Section 219 of the Constitution and Section 23. And if that is so, then the declarative must be counted. Now, if we then, my Lord, move to, and again, I acknowledge the overlaps, and hopefully, therefore, it's not going to take us too long to deal with the review aspect, because half of it, quite frankly, has been covered in everything that we've said earlier, particularly regarding the point about the bias and the absence of a hearing and the unequal treatment or irrational differentiation. But I was just troubled by something before we broke, my Lord, where the Lordship was suggesting that the respondents are not saying that because of the expression, I think, is of the financial burdens which are allegedly caused by the
set of issue.
Yes.
In quotation.
Yes, absolutely. Yes, that's exactly in quotation. But my Lord, I really would. I'm not going to develop the point further. I want to employ your Lordship simply to read the case for both respondents. The reason that they go to town ad nauseum about this and that charge, and then even compromise the safety of the lawyers by saying the lawyers end this much so that we can be mauled by kidnappers, and all that long is only in aid of one thing. It is in aid of saying that a person who has impoverished, quote unquote, that office to that extent is ipso facto a victim of the artificial forfeiture clause. And when I use the word set off, my Lord, I'm using it in the following sense. There's a case, and I will give your Lordship the reference tomorrow, which says that, it might even be one of these cases, which says that in those situations, the requirement of the law is that the employer should institute civil proceedings about whatever they think that they are owed. They can't simply wake up and implement the equivalent of a set of quote unquote. And in any event, that is outlawed by the provisions of the Basic Conditions of Employment Act. Because the Basic Conditions of Employment Act says if you are going to set off anything for an employer, you must do so with consent, with the consent of that employer. I think it's paragraph 70. No, it's not 70 something. There's no 70 something. 7 bracket 9 or something. I'll get the reference. So it would not just be against the normal interest of justice, it would also be against the law. But let's put that aside. Let's then come to the review leg. The review leg of the case, my lord, is much simpler. And it is this. And for the purposes of this, you have to no. Let me do this one before I go to the review leg. Let me round off the other alternatives very quickly. So this is how the case is structured. We say one, the declarator that we've been discussing. If your lordship is with us with that, that's the end of the case. And then the lordship would then give remedial action in terms of 172(1)(b). But we say that if your lordship, for some reason, finds that this forfeiture clause actually exists, then that new clause, re-engineered to include the penal forfeiture clause, would be unconstitutional in the sense that it would be introducing an arbitrary standard which has no basis in law and is, as I say, extensible and elastic according to how everybody feels. Thanks. So the constitutional attack is in the alternative in that sense. Your lordship knows, I don't have to lecture your lordship about the Handay test. So the first duty for your lordship is that in terms of the Handay case, your lordship must in any event interpret these documents in favor of the citizen, in favor of liberty, and in favor of or against inequality, oppressiveness, and absurdity, and all those things. But if all that fails, then your lordship will be left with the reality of the clause that they postulate being there, and we say in that case that clause would be patently unconstitutional. And I don't have to motivate again for the same reasons that it would offend against the most basic norms of justice, as is said in the Wachenuka case, for example. And then, my lord, if your lordship then does that, what we call specific performance, stroke, you can call it specific performance or substitution, whichever way you want to call it, is that if that clause is then found to be invalid, then obviously your lordship's remedy would be to order that its application was ab initio unlawful and the gratuity must be paid.
That is if clause 3.1.
Yeah,
clause 3.
Let's say 3, yes. Just
right.
for
But the case made on paper is that, which is an alternative, is that that law be declared, as it were, to be contrary to public moral.
Yes, that's the same thing. It's saying public morals.
But why is that the case?
Okay.
On a facial consideration of the
Yes.
clause, why would it be
Yes.
as it stands?
Well, my lord, by definition, what used to be called the legal convictions of the community, the rechtsoortegens van de gemeenschap, which was a concept that was developed in the case of Evels versus Minister of Police. It is now tried that that concept, which was the embodiment of the Bonnie Morris of society, that concept has now been, is just as good as saying the Constitution. In other words, the nation has decided to embody its legal convictions in a document called the Constitution.
Yes,
so,
but forgive me, that is what the law says.
Yes.
Now, as to the substance, why is clause 3 said to be contrary to public morals?
Right.
Because that is the relief sought in the alternative.
Yes. The submission is this, my lord. Not clause 3 as it stands now. I've addressed your lordship as to clause 3 as it stands now. I'm saying the new clause 3 that has the forfeiture clause. That's why it's the alternative. So if the court finds that there's a new clause 3 which incorporates the forfeiture clause, in other words, that their case on the interpretation is such that there is such a forfeiture clause. I mean, I don't know how. But if that happens, then it is that clause 3. I don't know if it's clear now.
All right, I see.
Yes,
I follow.
that's why it's called the alternative. It is that clause 3 that would be unconstitutional, not this one. This one we've explained.
That's not how I understood the pleaded case.
Okay.
I understood, but I followed the submission. The submission is the applicant doesn't take issue with the clause as it stands, but to the extent that the court is with the respondent in interpreting the clause in the way that we've made the submission, that is incorporating the forfeiture clause as you have submitted, then in that event, the clause is to be clause 3 is then to be interpreted as being contrary to public morals. Is that the case?
No. The case is this, my lord. It is not that the applicant doesn't take issue with clause 3. That's what the whole morning is about, us taking issue with clause 3.
No, but we've gone past that. We're
yes,
now dealing with
we're
dealing with the alternative. I'm
Yes.
aware of that.
In the unlikely event that the court finds that there is a forfeiture clause incorporated in clause 3, then that resultant clause would be unconstitutional for, and I hope, I know that I don't then have to traverse the reasons why a penal forfeiture clause which deprives the rights that I've defined in the morning would ipso facto be it's like saying if there was a clause that says you can be arrested for no reason.
Okay, no, I follow.
Then that clause would be unconstitutional.
I now follow.
Excuse me. Excuse me. And your lordship will find that at 02-3, which is alternative to prayers 1 and 2, declaring the clause 3 of the public order to be illegal, null and void, unenforceable. Excuse me. Sorry, my lord. Anyway, that's the alternative. The next alternative at paragraph 4 is a simpler one, which says that prayer 3 respondents to be in breach of the clause and or the BCEA. I've also gone through that at length. In other words, it would be 32.3 of the BCEA. And all read, my learned friends, one of them at least, I think it's Mr. Mkhwebane, say that we're not entitled to rely on the other sections of the BCEA. I've never heard of a submission like that. If the end domain says when you interpret 32, for example, of of the BCAA, you must look at the statute holistically. So I don't know how we can say the court must just be blinkered to Section 32, but not look at the statute holistically.
Well, when the court retires and reflects on submissions, the court will need to know which provision of the BCEA is being referenced. Now that is 32 sub 3.
Yeah, that's in the founding affidavit actually. It says 32 sub 3. All I'm saying is that in interpreting that section, you can't not look at the rest of the statute. I've never heard of such a thing. But so it's always been 32.3 as pleaded in the founding affidavit. But that 32.3 cannot be viewed as an island. It must be viewed in this constitutional context as well as it's. But by the way, the preamble to the BCAA says to give effect to the right to fair labor practices referred to in Section 23(1) of the Constitution. So that's what it is. So it means also in interpreting it, you also have to look at Section 23. Then the other alternative, my Lord, is, in other words, there again, this obviously directly depends on the interpretation of the word remuneration. Because if your court is with us there, then 32.3 kicks in automatically. Then the further alternative, which is where we are now, is the review relief. The reason I'm rushing through these other alternatives is because in our respectful submissions we'll never get there really, because the declaratory relief is self-evidently established. And as far as the review relief is concerned, my Lord, this is what we're saying. At the risk of repeating myself, the organ of state is enjoined by Section 33 of the Constitution to grant certain rights before it implements a particular decision. That's just a layman's understanding of administrative law. And we say that in this particular instance, and again, this is why this is in the alternative, by the way. In this particular instance, you now have to postulate that, because otherwise you can't reach the review relief. You can only reach the review relief if you found that the forfeiture clause is good. Now we're saying if the forfeiture clause exists, then by definition it is what you call a penal clause. I don't think anyone in this room is going to contest that notion, that a forfeiture clause is one that imposes a penalty. In fact, in this case, it doesn't just impose a penalty, it imposes a double penalty, which the Americans call double jeopardy. It's because you've already, for the same conduct, you've already been punished by being impeached. Now they're saying you must be punished again by being deprived your gratuity. So it's worse than a penal clause, it's a double penal clause. But it is what it is. Let's assume there is that double penal clause. Now, if there is that double penal clause, as there is, by the way, for the case of a president, a double penal clause. Firstly, we say a double penal clause would have to be specifically promulgated. It can be implied. But for the purposes of administrative law, we say and this is tried, even before the Constitution came, this was true. When you have a penal type of clause, that automatically attracts Audi. That we can praise the Constitution for many things, but that's not why the Constitution didn't introduce. That was always like that in the olden days.
Mr. Mpofu, perhaps let's begin at the beginning.
Yeah.
In relation to this part of the review.
Yes.
The applicant contends for the conduct being administrative action.
The decision.
Well, that's one aspect which I needed to know as to what in fact the case is. So the decision is what constitutes administrative action on the pleaded claim.
Yes.
Now, in relation to the definition of administrative action, what does the sub A Roman 1 and 2, which heading does the applicant contend for?
Okay, section sub A and 2 of section 1.
In the definitions.
Okay. It says any decision, we accept that decision, or failure to take a decision. When organ of state, we accept that. When exercising a power in terms of the constitution or a provincial constitution. Well, according to them, this is the exclusion is in terms of the constitution. In other words, for example, when they say that we are wrong in the 89.2 provision, they say the exact opposite. They say actually the absence of the forfeiture clause proves their case, that the constitution also intended the judges and public protectors to be subject to a forfeiture clause. I mean, that's absolute.
Well, that's what they say in submission. What I do need to know is, in the first instance, under the definition sub A,
yes,
which of the two alternatives, Roman 1 and Roman 2, does the, well, perhaps I'm assuming. There's sub A, Roman 1 and 2, and then there's sub B in relation to the taker of a
yes.
decision. What does the applicant contend for? Which category does the applicant contend for?
My Lord, I've just said why it's first of all in the aversion category.
No, but see, that's what I don't understand. You say in the aversion, her case, because she's pleading a review in alternative.
Yes.
So I need to know where to locate that part as far as the act is concerned, not what they say,
Okay.
what she says.
Okay, all right. I'm saying, my Lord, I don't quite understand that, because when you come to court, surely you're coming to court because somebody has done something to you. And so I'm saying that the case of the applicant is that when the public protector were exercising a power in terms of the constitution, well, obviously not a provincial constitution. In other words, in terms of either section 2195 or the umbilical code that is explained by Musaneke J in the Goed 11 case, that's our first case, where Musaneke J says exactly this point, that when you are implementing a legislation such as the BCEA, in that case it was the Land Restitution Act, you must understand that it has an umbilical cord into the empowering section of the Constitution. I just read out section 23, the relationship in that umbilical matrix between section 23 and section 23. So the short answer could be something like this: which power under the Constitution are they exercising? I would say it's a power that emanates from both section 219 and section 23.
Forgive me. We seem to be at odds.
Yes.
I just have regard to the definition of administrative action. It says it means any decision taken or any failure to take a decision then by sub A and sub B. Now, I had asked earlier as to which category the applicant contends for. But I'm reminded from the pleadings that the applicant says that the public protector is a decision maker. That's a
Yes.
pleaded case.
Yes, it is. It's not just the pleaded case, it's what the public protector says herself. Right? She says at about 4 places. Sorry, my lord.
Right. The decision maker is the public protector.
Yes. She says, I'm just giving you a random example. If you go to paragraph 29-22, where the heading is the decision-making process. In other words, how the decision was made. She says, in this section, I address the process by which the decision was taken. Right? I demonstrate the decision followed a fair process which was initiated by the applicant. The decision itself was informed by lawful, constitutional, and rational factors in accordance with the responsibilities and so on. That's just one example. There are many places.
That is fine.
And then, sorry, my lord, I'm so sorry. I just want to finish this thought. At paragraph 48, she says, since no further response was forthcoming from Adhikare, that's Parliament, it became clear that it was the Office of the Public Protector that would take a decision on how to deal with the applicant's demand for gratuity. Sorry, my lord. Yes.
Yeah, well, I mean, the Office of the Public Protector and the Public Protector are not the same thing.
Yes. Yes. They're not. But okay. The public protector is itself a sui generis Chapter 9 institution. It is both an office and a person, but that is irrelevant for the purposes of this case. When we talk about, if you look at Section 5 of the PP Act, it says that, and you'll find that in the Section 5(1) of the PP Act, you'll find that at paragraph 17, page 17, sorry, of the HUD.
Yes.
Yeah, it says the Office of the Public Protector shall be a juristic person. Okay, so you have the public protector in that embodiment, which is the office. That's, if you go to look at the first respondent, it's called the Office of the Public Protector.
Yes.
Okay, so that's the first respondent. So we're done with that. Let's go to the second respondent. Is called Ms. Galeka, right? So that covers you always. That's how you always cite the public protector. Yes. And if you go to sorry. I'm sorry, my lord. This is. Oh, I'm so sorry. It's if you go to the notice of motion, not the notice of motion, the founding affidavit. Sorry, my lord. Paragraph 5 of the founding affidavit, that's 02-163, I think, if I'm not mistaken. But in any event, it's paragraph 5. This is how the parties are described. The first respondent, paragraph 4, is the Office of the Public Protector, also known as PPSA. Okay, that's the juristic person, whose head office is situated at Hillcrest Office, and so on and so on. Then it says the second respondent is Koleka Galeka, cited in her personal capacity as well as in her capacity as the public protector in terms of the Constitution. All right? So and this is a standard citation for the public protector because it caters for the notion that the office, like the Auditor General, the Auditor General is a person, but it's also an office. Unlike the chairman of ICASA and all the other public Chapter 9 institutions.
Mr. Mpofu, now in relation to a claim or a dispute in relation to administrative action, the Constitutional Court has said that there are 7 elements or requirements to the definition of administrative action. So that is a gateway which the applicant has to satisfy for purposes of the court being able to determine whether or not there was administrative action.
Yes, my lord. But those are trite propositions. It's not.
Well, I mean, the court is aware as to what the requirements are. The issue is whether the applicant has demonstrated them.
Yes.
So, and you'll find those recited in the decision of Minister of Defense and Military Veterans against Mutawi and others.
Yes.
The Constitutional Court,
Yes.
paragraph 33, I believe. Now, so the first one is that there must be a decision of an administrative nature. Second one is by an organ of state or a natural or juristic person. That's why the court was inquiring as to who the decision maker is on the claim. The third one is it must be shown that the decision maker was exercising a public power or performing a public function. Fourth, and that exercise was in terms of any legislation or an empowering provision. 5, adversely affecting the rights of the claimant. I'm paraphrasing. 6, decision having a direct external legal effect. 7, and that does not fall under any of the listed exclusions. Now, the applicant has to satisfy all these elements.
My lord, with the greatest respect to your lordship, if literal in every administrative or PAJA review, we would first have to deal with all those 7 things. My lord, for example, why must one have to show that this is in terms of an empowering provision? We've been saying the whole morning that there's the service conditions, that's an empowering provision.
Well,
the BCAA is legislation.
Now, forgive me, because I haven't had a case made as to what power
is being exercised.
No, that's something different. I haven't had submissions as to, for example, what legislation or empowering provision the decision is said to have been made in terms of.
Whenever a public body writes a letter like the one it did on the 12th of February, and it says to you as a citizen of the country, I will not do this or I will do this because I am, as I say, that's where we started at 10 o'clock this morning. It can only be saying that I will do this or not do it because I am constitutionally empowered to do so. That is a matter of, it just goes without saying. Well, otherwise, it's not like me. I can do something and they say why, I say I just feel like it. But an organ of state cannot do that. An organ of state can only do anything, literally, even breathing, only in terms of an empower a constitutional...
No, it's the other way around in this instance, because you are the claimant. You have to demonstrate, for example, what power was being invoked, and as part of that demonstration, you might be able to say, relied on the wrong source. That wasn't.
Okay.
They say they
That's
acted on the basis of this.
Yeah.
They couldn't have acted on the basis of that. So
Yes.
it's for the applicant
Okay. Okay. Let's
to demonstrate.
Fine. Let's do it like that then. Okay. They say they acted in terms of a forfeiture clause, which they say should be imported into the empowering provision, which is the service conditions. Okay. So that's what they say. That's effectively what. If you read that letter with legal eyes, that's what they're saying. They're simply saying, in terms of the what you call it, regulatory framework, which contains all the things we've been talking about, we can distill a clause. That clause itself, by the way, is an empowering provision. But for that imaginary clause, for the purposes of this, we assume that it exists. Okay. And then we say no, you can't, because the actual empowering framework, I'm using that word loosely, is interpreted in this way. So that's why we said the whole case is about interpretation. They interpret the regulatory, constitutional, and contractual framework to give them the forfeiture clause. We interpret the same framework to say there's no such forfeiture clause. That's what the whole case is about. But there is no... This is what I was trying to explain in the morning, the difference between a civil case and one like this, where the traditional owners say, well, you are the applicant. It doesn't work like that in constitutional and administrative law, because we're here about the culture of justification. Once you have established, for example, the prima facie, for example, it should...
Well, that's not quite right, Mr. Mpofu, because, for example, the court in Sokela and others against the MEC for Agriculture and Environmental Affairs, KwaZulu-Natal, 2010-5 SA 574, the court there said that the requirement that the decision be of an administrative nature is a gateway to determining whether a particular decision constitutes administrative action. So,
yes.
So it is required to go through the exercise.
Every time. Okay. So if let's assume that is so, my lord, that every case, every court which has to deal with administrative action, the denial of a dog license or anything, has to go through the exercise of saying, okay, well, was it an organ of state? Was it about an empowering provision? What, did it have external legal effect? Did it affect your rights? And so on. Let's assume that's actually how it is. The point we are making is simply this, my lord. Well, we don't think that it would be necessary. Let me just give an example, my lord, and if your court will bear with me. If you say, what is meant by external legal effect? It simply means that it has an adverse effect on the citizen, or whoever the complainant is, even if they are not a citizen. The person who has been affected by the administrative action. You have to take this from Section 33, my lord, of the Constitution, which is where it comes from. It says everyone, that includes this applicant, everyone has a right to fair administrative action. So and everyone has a right to a hearing. Everyone in the exercise of that. And I take your lordship's point, which is that everyone has to, if they are at least exercising Section 33, has to demonstrate that you are in the realm of Section 33. But I'm saying, and I'm going to leave this at this, my lord, because otherwise it will take literally all day here. That those, and your lordship is quite correct, those 7 elements, my lord, I will argue that those 7 elements are blatant in the pleadings, because we do allege, one, that, for example, the Public Protector's Office is an organ of state, as if we even have to say that, but it's there. We do say that it affects rights, we list them. We do say that it affects a livelihood, so that's adversely, if you like. We do say that the empowering provision does not, and the relevant legislation does not say gives them the power.
Yes,
so
but,
all
but,
those
but,
things
but
are
the
there.
point is, what is the empowering provision or legislation as far as the applicant is concerned? Because she has to say, as far as my case is concerned, this is the legal instrument that I contend for. But
Sorry
if,
again.
if
It's
forgive me,
the
forgive me.
service conditions, right? The thing called the service conditions is an empowering provision. And each party here in this room says that that's what they were implementing. The only difference between the parties is whether the implementation, in the implementation of that empowering provision, is this or that interpretation. The second one is the Constitution of the Republic of South Africa. Because each party, again here, says that the Constitution of the Republic of South Africa empowers it to do what it did or didn't do. The parties happen to differ on how to apply the Constitution. But there is no difference between any party here as to whether or not this is a... In fact, at 02-34, you'll find that this is what Ms. Daleka says. As is evident from the dispute, which is really what we're saying. This case presents serious constitutional issues, particularly related to the removal of office bearers of Chapter 9 institutions supporting democracy. So what is she saying there? She's saying that it's evident and clear from the pleadings and this common cause that the constitutional issues that are so that again, so your Lordship gave me that Roman 1 or Roman 2. That shows that according to everyone in this room at least, the issue is under Roman 1. But my Lord, let me do this really, because otherwise, as I say, it will just go on for a long time. Your Lordship, we rely on what is in our papers. I'm not going to make any submission regarding any further submissions rather regarding the applicability of PAJA, apart from what we have explained in the pleadings as they stand, what Mr. Lega is saying, and how we have dealt with it in the reply. So let's call that the point in limine. The point in limine, that is, and by the way, and the only reason really that I'm addressing that is that as far as the Speaker of Parliament is concerned, that's the only point they take, the point in limine about administrative action. The other side, wisely, dealt with the actual grounds of review, because you can't put all your eggs in one basket and not deal with the actual grounds of review. So let me do this. I'm going to deal with the grounds of review, and for the purposes of this discussion, it should not matter whether I'm relying on PAJA or legality, because quite frankly, this debate also doesn't take us anywhere, because if PAJA doesn't apply for some reason, either because there's no external legal effect or whatever, the review is brought under the principle of legality. So the review relief is not going to go away just because it's not administrative action. So I'd rather address it from that point of view. Let's look at the legality review. Now, the legality review, my lord, is and please, I don't want to be understood to be saying that the PAJA grants do not apply. I've made my submission. I'm just saying I'm not going to address it further.
You stand by what's
in the papers, what's in the literature, in all the cases and all that. Yeah. But let's talk legality. Now, the legality review, my lord, is patently based on the following grounds. There's something called procedural irrationality. A lordship might know that this comes from cases like Albert, Law Society, and various other cases. And it really is what you like, if you like, a manifestation of the how irrational it can be in certain cases to deny somebody their rights to make representations or to a hearing or reasons or whatever, all the fairness standards.
The respondents say that insofar as a claim for not having had a hearing is concerned, I understand their case to be that the applicant sent a letter inquiring about the payment, and then there was that exchange of correspondence,
Yes.
which you have mentioned to the court, which culminated eventually with the applicant being with a letter of the 12th. And that they say that that constitutes a hearing.
Well, okay. I don't think they can go that far, but let's assume that they do.
Forgive me, so that's one aspect. They also say that the applicant, in any event, doesn't say what that hearing that she contends for, the form that the hearing should have taken.
Yes, my lord, but that's just palpable. I don't even know how to explain it. Firstly, where does the duty come from an applicant to say this is the form of a hearing? If you owe somebody a hearing, you owe them a hearing. You can't say that they now assume some duty to say no, it must be done in an air-conditioned office, or it must be done in this place or that place. There's no such thing. The duty arises.
Forgive me. How can the applicant not have an interest in the both the form and content of a hearing, while simultaneously saying that she did not have a hearing? I understand the complaint to have within it an expectation of what should have happened or what ought to have happened, such that had that happened, then, according to her, she would have had a hearing.
Well, my lord, really, I must say, it's the first time I hear that the somebody who's complaining of not getting Audi, in other words, let's say an employee, you get kicked out and they say you're fired, and they say, well, what about my hearing? Then they say, now the employee then attracts a duty to say how that hearing should be held, where it must be held, and all sorts of things like that.
But then
where does that duty come
from? If that
from?
is so, and if the court is invited as it is to make that finding, how is the court to say that she should have had a hearing and that hearing must have had the following elements?
Okay. I've answered the first part. How the court should determine whether she should have had a hearing. That arises out of the law. if it's a penal provision, you must have a hearing. That's how. The second aspect as to the form of the hearing, as I said, that's the part that I'm hearing for the first time. That then she must not only say, I was sent to jail without a hearing, but that hearing should have been in the form of a motion proceedings or a criminal trial or a civil trial or whatever it is. No, the mere absence of a hearing, which, by the way, and in defense of my learned friends, none of them has said that there was a hearing. What they are saying is that there was no need for a hearing, and I'll find. In other words, they ignore the fact that this is a punitive statute, which ipso facto, a decision with ipso facto attracts a hearing. But again, let me move on. And I'll make my submission at this and leave it there. One, the duty to have a hearing arose. It arises from everything: the common law, the constitution, fairness, any sense of justice that anyone can think of for anyone who's going to be punished. Then the point is that there was no hearing of any description. So you can invent any hearing you like. You can say it should have been in a formal setting, should have been in a community hall or whatever. None of those happened. So there was no hearing of any description on our version. And to the extent that the exchange of letters is alleged to be a hearing, that is shocking, to say the least. Because you can't have a hearing by somebody saying, please pay my gratuity, and then you come back and you say, I've made a decision that you're not entitled to it. Where's the hearing? How you do a hearing is the following. You say, you go to your senior counsel or whatever, and they advise you that there's a forfeiture clause. Then you say, okay, I've now discovered that there's a forfeiture clause, and because it is penal in nature, I want you to make representations as to why it should not apply to you. You now, no, not in general. That's what a hearing is. If you stab somebody in the street, you get a hearing in the criminal court, because they don't just say, well, you've just stabbed someone, therefore you must go to jail. You must get a hearing to show why you must be exempted from that operation of the law. It's Audi in every form. Yeah. Same thing. If I crash somebody's car, they take me to the civil court to get a hearing. I get a hearing, then I can explain that no, I had a disease or whatever it is. That's the hearing. Now, in this example, the hearing would be, well, the former public protector would say, no. All the things that we're saying now, we wouldn't have had to come here. By the way, one of the functions of a hearing is to avoid having to come to a court, because in that hearing, if you are dealing with an honest organ of state, they might say, oh, we didn't think of that, or we didn't think of the Remuneration Act of the judges, and so on and so on. Therefore, so you can't just say you believe your own I almost said propaganda.
Right. Which other basis does the applicant rely on for her claim based on legality review? You have been mentioning procedural irrationality. What other grounds?
Procedural irrationality.
What other grounds?
Okay. The other ground that is pleaded is the bias. And bias, malice, and what you call the perception of bias. Again, that falls under both the perjury, but it also falls under the common law. So a Lordship will know, for example, when you are asking for a recusal of a judge, you are invoking bias, but not a la perjury, because perjury doesn't apply.
And the respondents say that the complaints of bias, malice are unsubstantiated.
Yes, my lord. That's what respondents do, my lord. I can't. Okay. This is how they are substantiated. If that's supposed to be their defense. These complaints are substantiated in great length in the papers, my lord, to show that, firstly, the mere fact that we're here is an act of vindictiveness and really capriciousness, arbitrariness, whatever you want to call it, because because it's the first time that a party that says, I don't have the power, I don't know if I have the power, and then all of a sudden one day wakes up to say, I now do have the power and I'm going to exercise it against you. It's also the first time, my lord, that a party which has been told ad nauseum that there's a reason why there's section 32(3) of the BCEA, for example, which says you must be paid 7 days after the termination of your employment. It is for obvious reasons that it is at that point that you are stranded, quote unquote, and you need to be able to be remunerated so that you can have a livelihood. We are now 3 weeks or so from the anniversary of the termination of the contract, a whole year. And all that has happened is that the person is being punished for a reason that is completely arbitrary and has no basis and has a shifting parameter of the reasons why it is being done. That's not enough. We have we then bring, after the letter of the 12th, bring an urgent application on the 1st of March. The reason why this application is being heard now on in August is because, and this is all in the papers, the applicant did something which is completely unheard of. For 6 weeks, having been asked to produce a record in 5 days, for 6 weeks they did nothing. And on the eve of the hearing, they produced what we say was an incomplete record and no reasons. The reason they didn't produce the reasons was because they say the reasons are in the letter of the 12th, and I've made submissions about that. But the reasons why they didn't produce a record, we don't know. And if organs of state all over the country can adopt that attitude of saying when a citizen brings an application, when you are bound to follow the time frames that they set, you can just carry on with your life as if nothing has happened. And that is why your sister, Collis J., imposed an attorney and client cost order against and that's also in the papers, against the applicants, because it's not done. We have shown, and I don't want to get into this in great detail, but we have also demonstrated, my lord, that in the first place, the impeachment itself was accompanied by sustained conduct aimed intentionally at denying the legal representation, despite what the Constitutional Court had ordered. Constitutional Court said there is
the impeachment process is not before this court, or is it? I mean, the issues pertaining to that, other than it being a recordal that the applicant went through the process and decisions were made in terms of that process as detailed in the record.
Well, thank you, my lord. If that is the case, then why are we here? Because I thought we were here because the case of the respondents is that the impeachment of the public protector for misconduct and all the things that they then go on and incompetence is the reason why they are not paying the gratuity. So I'm glad if indeed your lordship is quite correct that the impeachment process and its ins and outs is not before this court. Well, then I should just sit down, because the very essence of why it is that the gratuity has not been paid will be not before the court. Because the second manufactured reason, which appeared in the answering affidavit, is solely based on nothing else but the impeachment process and its findings. But I agree with your lordship. It shouldn't feature. So then the basic, the real justification. Let's remember where we started in the morning. Culture of justification.
No, forgive me. I think we've made submissions on that. Right. So then, bias, malice, and perception of malice. That's the second basis to the legality review. Are there other grounds?
Yes, there are. The other grounds is in the document, which is taking into account, and unfortunately that also takes us to the impeachment process, which is really the only thing that brought us here. We say that they took into account irrelevant considerations in making the decision. And again, I hope everything that I've said this morning makes that clear. But to the extent that I have to motivate that, the irrelevant considerations which they have taken, the first one is the true reason, which is that you did not vacate of your own volition. That's completely irrelevant. There's no such thing in the legal framework about volition or non-volition. We've shown it with the reference to death. The second one relates to the manufactured reason that came later, which is the one about misconduct and incompetence. And as your lordship has correctly pointed out, that would bring into this case something completely irrelevant, which is the outcomes of the impeachment process. And the corollary of that is this: there is no moral stroke fault-based stroke turpitude-based qualification to the entitlement of the gratuity, to the extent that it is being introduced, smuggled into the legal framework. That is an irrelevant consideration, and that's clear because well, firstly, even if you look at the volition standard, that doesn't exist, or you look at what, let's call it the blemish, the new one.
But you've made submissions earlier on
yes,
this point.
Yes, but my lord. So I said when I started that when the submissions with regard to the first leg and this one's overlap. But it's my duty, my lord. If your lordship asks me if there's any other ground to answer to that ground and then show how it relates to this case, I would have thought. Yeah.
Yes. No. Yes. I have made a note.
Yes. Okay. So I'm answering the question. I know your lordship didn't pose it, but the question is, if you say, you can't just say they've taken into account irrelevant considerations. I have to tell your lordship what those irrelevant considerations are, and that's what I'm busy doing. And those irrelevant considerations are the whole, I don't know to go chapter and verse, the whole thing about the lawyers' fees, this, that, and the other, and that's why I was summarizing it into saying morally based, or turpitude, or guilt, or fault, or whatever. I didn't want to spell them out specifically. Your Lordship knows what I'm talking about when I'm saying that they say without blemish, or you must show that you are a good behavior, or whatever. None of those things. Like the judges, the gratuity would be payable. Even the only adjective that's ever put to the payment of a gratuity in terms of a judge is active. So it says if you resign after active service. Again, active service simply means you were doing your job actively, not excellently, not without fault or whatever, not because your judgments, if you took judgments for 6 months or whatever, that's all that is. The issue is were you in active service. It's quite a neutral term. And in the same way, the public protector has shown in the papers that she achieved clean audits. She did all that was required of her, and she was actually, it was the first time any public protector had achieved those achievements. So here's the example, my Lord, which maybe might come home easily. Let's go to the judges again. I don't want to mention names, but let's say there's a judge who, for all intents and purposes, has excellent service and active service. In year 15, and all these years they've been accumulating the rights to the gratuity. And then in year 15, they drive into the yard of a house. Nothing to do with their excellent judicial career. And for that, one thing leads to another, and let's say they break, their eyes move out or whatever, and then they have incapacity to change the story a little bit. And then they are removed. Now, you can't say, well, that person, which is really what the case is, that judge must forfeit all the 14 years of accumulated gratuity of active service simply because they've now been removed for something. So that's what this public protector is saying. She's saying, I performed my duties to the extent that I was found to wanting by Parliament. It's common cause that is being challenged in separate proceedings. There's no debate about that. That may or may not be found in her favor. I don't want your Lordship to even entertain that. For the intents and purposes of your Lordship is 50-50. It will be decided in that court. But what she's saying is that irrespective of the findings and the political machinations that might have resulted in my impeachment, which is being challenged, I was in active service, quote unquote, for 7 years, 6 years, whatever it is. Factor E.
Forgive me, I don't follow the submissions in relation to the taking into account of irrelevant considerations, which is a third ground.
All right. Okay, let me break it down. It is irrelevant in our respectful submission that, forget about the judge for now, that Ms. Mkhwebane, let's concretize it. It is irrelevant that Advocate Mkhwebane, for the purposes of determining the eligibility or non-eligibility for a gratuity, as your Lordship said, whatever happened in the impeachment process is an irrelevant consideration, because there is no standard by which that which happened there, good or bad or indifferent, can be transported into the service conditions or the Section 2195 of the Constitution or the Basic Conditions of Employment Act. Let me put it simplistically. The Basic Conditions of Employment Act says when your contract has been terminated, you must be paid your remuneration within 7 days. Full stop. It doesn't say if it's terminated and you have killed 1 million people or whatever. There's no such qualification.
Right. So you are submitting, as I understand, that whatever happened in the Section 194 process has got nothing to do with the applicant's entitlement to a gratuity.
Legally speaking, yes. I'm saying there's nothing in law that entitles. In the case of a president, obviously, it has an impact. But in the case of a judge or a Chapter 9 institution, there's nothing in law that entitles you simply because you've been found guilty of this, that, or the other.
Right.
To be
the point is noted.
Yes. So it's again. So it's either there is or there isn't. There either is something in law that says you may take into account how it is that you got removed.
And the case is that it shouldn't have been taken into account, and because it shouldn't have been taken into account, that renders it an irrelevant consideration.
Yes, and the point comes from the earlier point we made earlier, which was that the assume for argument's sake that the removal was for incapacity, for example.
Okay. Now, Mr. Mpofu, I understand the
Yes,
point.
okay.
If there's another one, please make it.
Yes. Okay. So that's the ground of review. It's a well-known ground of review that if a decision is motivated by taking into account irrelevant considerations, then it must be set aside. Then, my Lord, we have made other issues about arbitrariness. I won't repeat. I've already said why we say the decision is arbitrary. We've also made suggestions about what we call passing the buck. There's a judge who said there's no such ground of review, but there is. The fancier word is called abdication, which means when you make a decision and then you say someone else must make it, which is what happened with the Parliament, the toing and froing between Parliament and the public protector. They were saying, no, it's your decision, no, it's your decision, no, it's your decision. That's from a innocent citizen's point of view, that is irrational by the state or any of its organs. It doesn't matter for present purposes. All the ones that are before you, at least the two that are before you here. And then, when it comes to both parties, but even more so with the speaker, the speaker didn't even make a pretense of giving a record. That's irrational. Well, not only is it irrational, it's just illegal. Yeah? And no pretense of giving any reasons. And they have a solemn duty as an organ of state to...
But you are not contending that the speaker was a decision maker.
My Lord?
You are not contending, the applicant is not contending that the speaker was a decision maker.
No.
Or does she?
Oh, she does. She does.
So then there were... then the decision maker then, would that be the officer as a juristic person, the public protector as the person holding office, and then the speaker of the National Assembly? So then there will be three decision makers.
No, my Lord, please. That's not what we're saying. We are saying that the decision is made, okay, let me put it this way, it's made by the state, okay?
No,
Just bear with me.
the,
Just bear with me.
it's
please,
unusual to say that the state made a decision.
Yes. No, if your lordship, please bear with me. Okay, let's go to ground roots. Go to the heading. The reason why we've said Adv Mkhwebane versus Office of the Public Protector, Kollega Kalega, President of the Republic of South Africa, Minister of Finance, and the Speaker of the National Assembly, is because all those players, the reason why you cite those players, all 5 of them, including the Minister of Finance, is because you, as a citizen, what you're saying is that I am entitled to a gratuity. Any one of you, to the extent that a decision has now been said to me, who has any role to play in that decision, must give me reasons so that I can sue you, so that I can take you to court and give me a record. Right?
Well, I mean, you would sue other persons, rather, you would cite other persons in review proceedings, not because they are decision makers as such, but because they may have an interest, and that would be another basis for suing. But what is of moment is identifying the decision maker, which I thought you had done, but I now understand that the speaker is also a decision maker.
No, my lord, honestly, if you go to page 0428. You'll see this comes from the notice of motion, which is really what I was busy with, the duty of the speaker to give us reasons if she had any, and so on. We say that in terms of Rule 53(1)(b), alternatively Section 173 of the Constitution, in other words, if it doesn't fall within those review, the first, second respondents, and then in brackets, and or any other respondents who played any role in the impugned decision, are called upon to dispatch within 5 days after receipt of this notice of motion to the registrar the record and any outstanding reasons.
Right.
Okay?
The point is that the speaker did not produce a record, and I understand that is one of the variables in the taking into account of irrelevant considerations.
No, it's a new.
That's something else.
Yeah, this is something else. I'm saying that the failure, the conduct in the failure to give reasons to a party that has requested you to do so is itself an indication of irrationality, because you are compelled to do so by at least the rules of court, if nothing else.
So which ground under legality review are you now canvassing in relation to the speaker not having given a record?
It's the ground that is pleaded in the supplementary affidavit, which talks about this, which says that to the extent that the respondents failed, well, in terms of with this one, gave an incomplete record on our version and no reasons, and to the extent that the other one gave nothing at all, we say that is a breach. Illegality simply means that you've breached the law. It doesn't matter which law it is. Yeah. So we say that it's an act of illegality in its own right. The deprivation, by the way, is a deprivation not just of the applicant but of the court as well, of the full ambit of the case, so that it can be adjudicated. That was said in Helen Suzman case and so many other cases. The court might not think that's well, if the court doesn't feel inconvenienced, the applicant does by that conduct. Certainly. So in terms of that, either Audi as you generally know it, or Audi as it is described in procedural irrationality, and all the cases about that, the bias or reasonable perception of bias, and again, I don't need to the applicant
But
has.
you've made those points, Mr.
Yes.
Mr. Mpofu.
Yeah, and the third one is relevant, or fourth one, relevant or irrelevant considerations, and the fifth one is the failure to conform with the requirements of Rule 53. Sorry, my lord. And your lordship knows that there is, we say and I said this earlier, the decision is also irrational to the extent that it is in breach of the BCEA and or the rule of law. You'll find that at page 02185. And you read that with the supplementary affidavit. So, my lord, as far as costs are concerned, again, I won't repeat the submissions, but it should follow that, and as I say, your lordship can read between the lines, for example, between the lines as to some of the conduct which has already attracted punitive costs. But even since then, because unlike them, we don't want a double punishment. Even since then, it's our submission, or even before then, for that matter, it's our submission that even before the institution of the proceedings, the conduct, and I don't need to take your lordship through chapter and verse, the conduct of the proceedings, and even the inclusion of all these, not to mention the mentioning of legal practitioners by their names and how much they earned and so on, all of which has nothing to do with the issues here. It's just pure vindictiveness and malice, really. All of that whole basket of issues, which your lordship has already said do not feature here, is itself an indication of conduct which your lordship hopefully will discourage other organs of state from doing, because they don't have to. An organ of state should not be combative about this, my lord, and that's the point we make really at the beginning. We say that if the organ of state was genuine about not knowing what the law is, which happens to many organs of state.
The applicant seeks a cost order to be made against the person of the second respondent. Can you make submissions on that?
Yes, my lord. Yes, thank you, my lord. Yes. But maybe all that can be subsumed in what I'm about to say. If you look at paragraph 12 of the notice of the founding affidavit, we say, my lord, given the fact that the first or second respondent seemingly and mistakenly believed that there was no enabling provisions empowering the payment of the gratuity, an incorrect view stemming from the failure properly to interpret the relevant constitutional and other provisions, but we forgive them for that. We say it is not anticipated that they will oppose this application, which is intended to give clarity on that very question. However, and in the event of opposition, then a punitive order, of course, will be sought on the grounds that the failure to pay will not have been born out of a genuine misinterpretation of the law, but suspected vindictiveness and malice, which has no place in the public administration. Let me unpack that, because that's the same submission with the personal cost. So we're saying, here's a party that says, my lord, as they're entitled to, we don't know where the duty lies. We're saying, if that was true, and they really saying, look, we don't have, then we're saying, here we come to court, we get a court order. That's where the obligation will come from, at least, if nothing else. So, but by coming out guns blazing and making up new reasons and manufacturing the law and so on and so on. For what? What do they gain by Advocate Mkhwebane not getting her gratuity like the public protector, current one, is going to get hopefully when either she resigns or vacates the office for whatever reason? What do they get by singling her out from all the other public protectors since 1994 who have been paid their gratuity? Except the hateful intention and vindictive.
No, Mr. Mpofu, that's not entirely correct. They say that the applicant is the first ever public protector to have been taken through the Section 194 process,
Yes.
that certain findings were made about her, and that for that reason and others, it is not a surprise that she, unlike other past public protectors, is not due a gratuity. They gave an explanation. The applicant, of course, differs from the explanation given, but there is an explanation.
Oh, my Lord, I'm sorry. The law doesn't say you must have an explanation. You must have an explanation that makes sense. So you can't have an explanation that itself is the product of lies, because we've established that that version is the version that only comes in the answering affidavit. We've established that the version that Your Lordship has just repeated now could not have been the reason in terms of the letter, because the letter says nothing about findings. It says nothing about all the things Your Lordship is telling me. The real reason, which was cited in the letter of the 12th, does not have the things that Your Lordship is telling me. So how can you say they have given an explanation when that explanation itself is quite plainly contrived and manufactured? So an explanation, I'm sorry, doesn't hold it. It must be an explanation that makes sense, and an explanation that a court of law can...
Forgive me, the court does accept that the applicant no doubt differs with what the respondents are saying.
No.
But for what it's worth, they've put up a version to the court, and the applicant has dealt with that version, and the court will make a determination on reflection.
Okay, well, I have to say this at least. If in any court at least, or even in a disciplinary hearing, if somebody, they say, why did you do this? Why did you beat up the other employee? And then you say, it was self-defense. Then they show that it was not self-defense. Then later you have another explanation and another explanation, another explanation. All I'm saying is that by the time you give your explanation number 30, it can't be that a court can then say, now finally we found one that we like. And the explanation itself in a court of law, that's why we're here, it must have credibility.
Yes, Mr. Mpofu, yeah. I understand your case. Yes. Your case is...
that there's no explanation.
That your case is that what has been said in the answering affidavit, insofar as why the applicant is not due a gratuity, is an after-the-fact rationalization, because that's not what she was told when she was given the letter. So you've made that point.
Yes, that's the first issue, madam. The second issue is that assume now that in the letter they had made all those points. In other words, there's no ex post facto rationalization. I'm saying, as Your Lordship said to me 30 minutes ago, that that explanation, there is nowhere in the law which says you must, if a public protector or a judge or any other official has been found guilty of mass murder, they must forfeit their remuneration. So I'm saying, even forget about the ex post facto thing now. I'm saying in any event, that explanation doesn't hold any water, because it has no place in the scheme.
But you've already made that submission at length.
Well, my lord, then you must not ask me to comment on their defense if you don't want me to address it. You've said to me their defense is that the reason, good or bad or whatever, is that she was found guilty of certain things.
No, Mr. Mpofu, that's not what, that wasn't the exchange. The exchange was you were submitting to the effect that there was no explanation. And the court said they do put up a version on paper. And the court then indicated to you that you've made submissions that the applicant takes issue with the explanation because what is set out in the papers is not what she was told. Yes. So the court is not inviting you to recite the submissions made earlier.
Well, okay. Well, the court, I'm afraid, I don't know, maybe we can play the record. I've never said that they don't have an explanation. I've never said such a thing. They have an explanation. I'm busy making submissions to the court to show that that explanation does not hold any water. How could I? Anyone who has read these papers will know that they rely on the, what I call the fault-based, all the things
and
that
you have made that point already.
Yes. And I have to address this because it has been raised with me. And I'm saying that even if you look at it benevolently and say that they have made that explanation, it is, on the words of your lordship, one that has nothing to do with the case before us, and certainly has nothing to do with the legal framework. Now, that cuts two things. It cuts the issue on the issue of bias, vindictiveness, and all that, but it also cuts on the issue of cost, and on the issue of personal costs in particular, because clearly, from the evolution of this matter, starting from March, we've given you blow by blow as to what happened when the legal representation was withdrawn, and so on and so on, right up to today, literally, of the continuum of conduct on the part of the second respondent as the purveyor, if you like, of the vindictiveness and malice and all the things that we allege, and making up of reasons and so on, everything I've said before. And for those reasons, my lord, and because of what was said in the case of South African Reserve Bank versus Public Protector, which incidentally, one of the reasons why personal costs were given to the public against the Public Protector there was non-compliance with Rule 53, which is exactly what I was trying to explain here earlier. But for all those reasons, both punitive and personal costs are called for. My lord, if I can just, what is it? Yes, just give you, I won't even motivate, I'll just give you this reference. Siriti and another versus JSC, 2023, bracket 5, SA 304 GJ.
Right.
That's the case that deals with what we discussed in the morning, my lord, about the congruity between the charges, the remuneration, the gratuity, as it applies to charges and as it applies here. My lord, well, we do have on the other alternatives. I want to address them. We do have other submissions. We'll cover whatever comes from the other side in reply. Sorry, my lord. Which answer? I'm sorry, I'm already sorry. page. Yes. Okay. Malene, I have to trust my junior that this deals with the issue of empowering provisions, and I think it also deals with irrelevant considerations. Paragraph 65 of the answering affidavit of Ms. Taleka say the applicant alleges that the decision maker took into account irrelevant considerations, in particular the fact that the applicant had not vacated office of her own volition. I have explained above why this fact was highly relevant to the decision. It is a relevant consideration because conditions of service distinguish between situations where the public protector vacates office at the expiry of the term and when they are removed from office. In the applications of the conditions of services, this was therefore an important fact. Yes. So that's the version which is based on the empowering provision of the service conditions for the case of Ms. Taleka. Let's go this.
Yes. Thank you, Mr. Mpofu.
Thank you,
Yes. Mr. Mkhwebane.
I want to propose that we adjourn, and it's 15:52. It's 8 minutes before 4. I can start at 10.
It's been an extended 2 hours.
It has been. I've been here before, but could I just propose that the most practical thing is to adjourn and resume at 10 o'clock tomorrow?
Yes. Well, the court can sit earlier if the party says sit.
I've asked Mr. Mutao about 9:30. I haven't asked Mr. Mpofu because
Yes.
he was on his feet. And Mr. Mutao, what was your answer?
Perhaps the court doesn't want to know. We'll sit at 10 then. If
10 o'clock. Well, my lord, let's take 10 o'clock. Let's see. We might try and assist your lordship by focusing the arguments. But I don't want to make commitments that my attorneys would disagree with. But the afternoon might help us. But let's not blame anyone. There's a lot of blame that's been passing around today. Thank you, madam.
yes, Mr. Mpofu.
Yes, my lord. That's the court position. My lord, well, Mr. Mkhwebane is already in the back. If Mr. Mutao has no objection, I would propose that we start at 9:30, madam. Your lordship has already said your lordship has no problem with that.
Yes.
So that also we because the danger is that if that doesn't happen, then we might need that half an hour at the end. Rather, it's always easier to do it at the beginning.
Yes.
So in the morning while everyone is still fresh.
Hear what Mr. Mutao has to say.
No, I know what it is.
Well, I'm entirely in your hands.
Yes. Well, then my hands say that the court will sit at 9:30.
As court business.
The court will rise.